tarde a todas as pessoas que nos assistem. Eu me chamo Gabriela, sou doutoranda em psicologia pela UFSCar, estudo tomada de decisão de jurados em casos de feminicídio, com coorientação da professora Ana Pastore. Sou membro da comissão do Comitê Científico do 8º NADIR e pesquisadora no NADIR já há alguns anos. E hoje eu tenho o prazer de apresentar a vocês a nossa conferencista, a professora Valerie, que vai expor a conferência Julgamentos por Tribunais do Júri, uma perspectiva global. A professora Valerie foi minha supervisora durante o doutorado sanduíche, e na mesa de abertura, tanto a Ana quanto a professora Laura mencionaram, né, a importância desses diálogos e da construção dessas redes, a partir desses períodos que nós passamos no exterior, construídas também graças a bolsas, no meu caso oferecida pelo governo federal, né, a Bolsa CapSprint, e a ideia é que essas parcerias se estendam para além dos períodos em que nós efetivamente ficamos fora, né? E essa mesa é um pouco reflexo desse movimento. A professora Valerie, atualmente, ela é professora da Cornell Law School, que é a faculdade de Direito da Universidade de Cornell. Ela é formada em Psicologia pela Universidade da Califórnia, em San Diego, nos Estados Unidos. Fez o mestrado e o doutorado em Psicologia Social na Universidade de Toronto, no Canadá. E desde essa época, né, da realização do mestrado, do doutorado dela, na década de 70, ela já pesquisava o tema do júri e assim continua fazendo até hoje. Ela é autora de mais de 10 livros e 150 artigos. Vou apresentar apenas, muito brevemente, alguns deles apenas a título de exemplo. O livro mais recente dela é o Juries, Lay Judges and Mixed Courts, que é este daqui, muito bonito, por sinal. Né? Os países em azul são todos os que têm algum sistema de participação leiga no sistema de justiça, né? Entre elas o júri. Ela vai falar um pouquinho mais sobre esse tema na conferência de hoje. E o artigo mais recente dela, publicado este ano, né, em 2023, em coautoria com a também professora que pesquisa júri, Sherry Diamond, é intitulado Fair Juries. Neles, as autoras elas abordam júris de grande repercussão e exploram ali algumas fases desse julgamento que são importantes de serem observadas para que se chegue a um julgamento justo. Vou mencionar mais brevemente também outros 2 artigos publicados no ano passado por ela, que eu considero bastante relevantes para essa área. O primeiro é o Gentlewoman of the Jury, que aborda o júri em articulação com o gênero, e o segundo é denominado Virtual Juries, que analisa essa figura curiosa, né, dos júris virtuais que surgiram aí durante a pandemia. Infelizmente, quase toda essa produção é em inglês, né, mas ela tem também pelo menos 2 produções relativamente recentes, também publicadas em espanhol, que eu também gostaria de mencionar. A primeira foi publicada em 2014, é a obra, e aí eu vou me arriscar no portunhol aqui, me desculpem qualquer equívoco, mas é El Juicio por Jurados, Investigaciones sobre la Deliberación, El Veredicto e la Democracia, e a outra é um relatório de pesquisa publicado mais recentemente, em 2021, que está disponível, inclusive, online, denominado El Jurado Neuquino, El Comienzo del Jurado Clásico en la Argentina. A professora Valerie, inclusive, ela foi consultora também durante o processo de implementação do júri na Argentina, né, que aconteceu recentemente, agora na última década. Ela também já foi presidente da Law and Society Association, que promove um encontro anual da instituição. Hoje ela continua atuando nessa organização, sendo uma das coordenadoras de um dos grupos de trabalho, o Lay Participation in Law, que aborda a questão da participação leiga no sistema de justiça. E, enfim, poderia aqui continuar falando bastante, pois o currículo da professora é bastante longo. Destaquei apenas alguns pontos que eu própria considero também mais interessantes de mencionar aqui, e convido vocês também, né, a pesquisarem mais desse trabalho dela, a pesquisarem o nome dela em plataformas como o Google Scholar, passear por essas publicações que são tão interessantes, né? E antes de passar a palavra a ela, gostaria de agradecer a equipe da Síntese, que está aqui nos bastidores, dando todo o suporte para a realização do evento, assim como a Ana também, professora Ana Pastore, e agradecer a síntese também por ter realizado a legendagem dessa conferência, né? Ela foi originalmente proferida apenas em inglês, então a síntese acrescentou aqui a legenda em português para que essa conferência ela se torne mais acessível. E também aos nossos as verbas, né, que foram também conferidas ao evento do PPGás, e enfim, outras fontes aí que permitiram que a gente realizasse também, né, que arcasse com os custos desse trabalho de tradução e legendagem. Eu voltarei ao final para fazer alguns comentários e passar alguns avisos, e desejo a todos uma ótima conferência. Muito obrigada.
Greetings. I'm Valerie Hans, the Charles F. Recklin Professor of Law and Professor of Psychology at Cornell University in upstate New York. I was delighted to get an invitation to speak with you about trial by jury and encouraged to take a global perspective on the subject matter. And that's what I'm going to do today. I've been studying the jury system for many decades and am thrilled with this opportunity to be able to share with you some of what I've learned over that time. In addition to talking about the institution of the jury and what is happening around the world with trial by jury, I'm going to be sharing some information about what social scientists have learned about the institution of the jury and how it functions. And I'll pay particular attention to some of the excellent work done by anthropologists. I want to begin my presentation with a map. This is a map of the world, and the countries are colored gray or blue. And one of the interesting things about the countries colored blue is that every one of them has some way in which it uses lay ordinary citizens who are not trained in law in legal decision-making. And that includes, of course, both the United States and Brazil. The countries in gray here have no form of legal decision-making by lay citizens. All of their legal decisions are done exclusively by people who are trained in law. And this map actually is a manifestation of a research project I did with the talented criminologist Sonia Kutenjak-Ivkovic, where we surveyed the countries of the world to discover which of them had what particular forms of lay participation. So this is one of the figures that comes from that research project with Sonia. We discovered that close to 2/3 of the world's countries had some form of lay participation in decision-making. As you can see here, the most common form by 71 countries is the use of mixed courts. That's a forum where both lay people drawn from the general public or drawn from special groups combine forces with law-trained judges to form a mixed court or a mixed tribunal, which decides on the case in criminal trials. Often they will decide both the guilt or innocence of the defendant, and then also the sentence will be decided together. Next most common is trial by jury, including our two countries, but then also 54 other countries around the world. And two lesser forms of lay participation, but still significant, are the use of lay courts, and a number of countries use courts that are outside the formal legal system, but still resolve disputes. So tribal courts and indigenous courts might be examples of these kinds of courts. And finally, lay magistrates, where people who do not have formal legal training serve as lay judges and might decide together with other lay judges or by themselves, as is commonly the case in the United States with so-called justices of the peace, who preside over courts with moderate and less serious crimes. Now, interestingly, a substantial number of countries also have options for the use of lay participation in civil cases too. This graph is a product of some of the research that Sonia and I have done, and also done by Jeremy Boulanger-Bonnelly, who had surveyed the world's countries for evidence of the use of lay judges. So it's really quite fascinating. 61 countries use mixed courts, so that's not far off from the use of lay people in criminal trials. Often these mixed courts in civil cases involve some form of lay expertise. So in a business court, for example, they might have a law-trained judge combining or joining up forces with people who have particular expertise in business. Or labor courts, for example, often have a law-trained judge, but then a representative from labor organizations, and then a representative from the business community. So it's a mixed court, but one that combines two different forms of expertise. You can see there are also juries, lay courts, and lay magistrates in civil trials, but notably the number of countries with juries in civil cases is quite substantially lower than it is in criminal cases, giving us the idea that the jury in criminal trials really plays a very significant and special role in standing in between a citizen who is a defendant and the government. So it's fascinating. Even though we have a lot of countries around the world that use lay participation, have it in their statutes, many have a provision for trial by jury in their constitutions, the actual proportion of cases that are decided by juries in particular is really quite low. So in the United States, for example, well under 5% of criminal and civil cases are decided by juries, and the pandemic has put even more pressure on that number, pushing it downward to 1 or 2% in some jurisdictions. So there's been a decline in reliance on juries and a fairly low proportion of cases that are actually decided by juries. And I'll talk a little bit later about how they're still significant, even though they might decide only a fraction of the cases in any one country. So part of the decline or the move away from trial by jury in particular, where a group of individuals goes off by itself and in most cases, except for Brazil, deliberates and arrives at a decision without the input of a professional judge sitting with them. Some of the criticisms of that form of lay participation have to do with the jury's abilities, their competence as decision makers, and also their fairness and the possibility that lay people left off by themselves might be biased. Another kind of common view reflected in some of the movies that are about trial by jury is that lawyers can manipulate juries very easily, and certainly much more easily than they can manipulate law-trained judges. Another issue has to do with the fact that lay people chosen for juries usually do not have any legal training. So the idea of reaching a legal decision where you have to grasp the basic elements of a crime and determine whether or not the defendant's actions actually met those criteria require that you be able to understand and to follow and apply the law. So that's another kind of stumbling block in the use of juries and a concern about juries. But I would say some of these criticisms have led to a very positive thing for social scientists, because social scientists have taken up the charge to try to investigate trial by jury. And there's been quite a bit of research on juries as institutions, but then also as decision-making bodies. Some of it looks at individual jurors and how they reach a decision or reason about their decision-making, and other research looks more at juries as groups and tries to analyze the group behavior and the decisions that are used. Now, given the many interesting questions that people have asked about trial by jury, it's not surprising that a multitude of different approaches have been used. Some are more quantitative and some are more qualitative. They're experimental and non-experimental methodologies that have been marshaled to study this fascinating democratic institution. The favorite method from my field of social psychology is the mock jury, and I have conducted those myself. The benefit of using an experimental approach, of course, is that you're able to vary the information that might be given to the jury or something else systematically, a feature of the trial, a defendant's criminal record, for example, and observe the impact by comparing people who have that information and people who don't have that information. My very first research study, in fact, asked whether or not the defendant's criminal record was biasing, and whether jurors could follow a very common instruction that is given in cases where defendants have criminal records, and that is not to use the criminal record to assess whether or not the defendant is guilty of the present offense, but rather only to evaluate the defendant's credibility as a witness. And my advisor and I thought it was virtually impossible for people to distinguish between these different purposes of using criminal record. And indeed, we found that even if you instruct jurors or mock jurors to disregard the criminal record for the purpose of assessing guilt, it's pretty biasing all around, and they're really not able to distinguish between these different purposes of criminal record. So that's an example of the mock juror, mock jury research. I'll have another one in just a second. But in addition to the mock jury approach, people have studied juries by observing their trials, analyzing the language in trials, and in cases where juries deliberate in the deliberations, interviewing jurors after they have served to talk with them about their experiences. Other researchers, more quantitatively inclined, have done statistical analysis of jury verdicts and often examined the extent to which different features of the case are linked to different verdict outcomes. So, for example, in cases where we know a defendant has a criminal record, we can ask whether or not those are cases where defendants who take the stand and criminal record is revealed are more likely to be convicted. And indeed, we find that they are. So that's an interesting example of how a statistical analysis of actual jury verdicts and jury cases can complement a mock jury approach. In a study I'm doing right now in Argentina with some fantastic collaborators in that country, we are giving questionnaires to judges, attorneys, and jurors about the experiences they have after they have participated in a jury trial in that country. In the last 10 years, Argentina has embarked on quite an expansive program of incorporating trial by jury in a number of provinces. And it's quite an opportunity to be able to study a new jury system at work. And through these questionnaires, we're getting ideas about that. In a very few studies, people have recorded jury deliberations and under very tight circumstances and have analyzed them. Then there are a couple of methods that are often used by lawyers who are looking to get an advantage in jury trials that they have pending. One is to do so-called focus group research that is often very commonly used in market research, and that is to assemble a group of individuals and bring them together and have them either see a mini version of the case or tell them a set of facts and observe their reactions and ask them pointed questions about their response to evidence or to video clips of potential witnesses. And a final method that is used by some lawyers and their trial consultants is the so-called shadow jury method. And that's where people recruit individuals to sit in the courtroom alongside, the other members of the public, and then to meet separately and talk with the consultants about their reactions to what they observe in a so-called shadow jury method. And depending on how elaborate it is, one might even have the shadow jury come in and out of the courtroom as jurors are coming in and out of the courtroom, and they might actually deliberate as the real jury does in a case. So you can see this incredible variety of approaches to trying to understand the jury system, and we've learned a lot. I want to talk to you about some of the earliest research on the jury system, and I think you'll see that it's got some intriguing parts of it, but it also has some limitations. This was a project done by two social psychologists, David Landy and Elliot Aronson, and they conducted one of the first systematic mock juror experiments in 1969. And they used not people drawn from the community at large, but college students at the University of Texas, where they were teaching. They were students sitting in a university classroom. They got paper handouts of an accident case and made sentencing judgments. All right, so perhaps already you're recognizing ways in which this particular setting is not all that like an actual jury trial. Nonetheless, their results were kind of interesting. They gave everybody in this paper description a brief summary of a case. It was a case of defendant John Sander, who went to an office Christmas party and got drunk. Somebody offered to drive him home, but he declined. He got behind the wheel of the car, and the worst happened. He ran a red light, and his automobile struck and killed a pedestrian who was crossing the street, a man named Martin Lowe. He was charged with negligent homicide. In fact, his blood alcohol level was quite high. So the researchers varied the qualities of the victim, Lowe. So in the so-called attractive victim condition, as you can see here, they learned that the victim was a noted architect and a prominent member of the community who had designed many buildings throughout the state, was an active member of the community welfare board, and even more, at the time of the incident, he was on his way to an orphanage with Christmas gifts, and he was survived by his wife and two children. All right, so that's your attractive victim. And here our defendant has run over and killed, because of his drunkenness, has run over and killed this attractive victim. And then there was the unattractive victim, who was a notorious gangster, in contrast to our charitable Lowe. He was a notorious gangster and syndicate boss who had been vying for power in the syndicate, controlling the state's underworld activities, and had been involved in a massacre of a number of men. He was carrying a gun, a loaded gun. He had been out of jail on bond, awaiting trial on a double indictment of mail fraud and income tax evasion. So we have in one set of one scenario, our defendant runs over an unattractive victim, and the other an attractive victim. So it wouldn't surprise you then to see when our mock juror students sitting in the classroom at the University of Texas responded to, how long would you sentence the defendant when our defendant ran over and killed an attractive victim? They were much more likely to sentence the defendant with an average of 10.55 years compared to the unattractive victim, 8.48 years. All right. So I remember reading this particular study as a graduate student myself and thinking, boy, that is interesting, but seems to bear very little relationship to real juries and real jury decision making. And yet it was published in a very high-profile journal, the Journal of Experimental Social Psychology. It was steeped in theory, this theory of attraction, and actually turned out to be quite encouraging of other social scientists to study the jury using the mock jury methodology. However, it was roundly criticized by lawyers for not being realistic, and in fact set back research, I think, by being a model of a mock jury project that was really more oriented around understanding psychological theory than it was understanding the real world reactions of trial by jury. So some of the other early work, including qualitative work, really dealt much more with juries in action and paid more attention to the actual context within which juries operated. In one very influential book called Reconstructing Reality in the Courtroom, two political scientists used qualitative research to analyze accounts that, or stories that jurors constructed about the evidence that they heard in trial. And it turns out this was a quite influential. Reed Hastings, Nancy Pennington, and Steve Penrod, three jury researchers and cognitive psychologists, were inspired by Bennett and Feldman to develop the so-called story model of jury decision-making. And today it's, I would say, easily the dominant method, our dominant understanding of how jurors respond to evidence and interpret evidence in the case. It's also fascinating to me that the field of jury studies includes people from a wide variety of disciplines, even though my discipline of social psychology is very well represented. There is some great work, terrific work by anthropologists, and I wanted to share several new pieces with you by anthropologists. Anna Offit has done fantastic ethnographic studies, and actually two different types of ethnographic studies. She's an anthropologist and lawyer by training, and she did one of U.S. prosecutors' offices where she interviewed the prosecutors and asked them about how they imagined jury trials, looked at cases and tried to anticipate how a jury would respond to a case. Really interesting work. She also did a completely different and independent research project of lay participation in Norway, which was undergoing substantial change during her time as an ethnographic researcher, where she observed trials and interviewed a number of participants and wrote about that fascinating experience. Robin Conley is another person with anthropological training who examined how language is used in death penalty trials in the United States. And a final example by Catherine Culver at the University of Pennsylvania currently did interview jurors about how they thought of themselves as legal reasoners. So I'll give you just a few examples from these projects to show you how this qualitative work operated on the ground. So Catherine Culver, we'll start with her. she interviewed jurors about their reasoning method. And here's just a quote from one of the jurors she interviewed, a man named Charles, who performed the role of the competent juror. So in his mind, this is what a competent juror would say and what was encouraged by the legal framework, but then also by his own values and norms. My mind was open until when the evidence was presented to me, I weighted it all. So he emphasized the openness of his mind and his refraining from making a decision until he had heard all of the evidence of the case. And one of the judges that Anna Offit interviewed in Norway, he reflected on the advantage of that he had over lay judges in the mixed court system that Norway has. I have experience. I know the words and I can argue. They can't. And that's a fact, even if they're well educated. Of course, I will control the situation when I meet a lay judge. I mean, that's a very powerful quote and actually underscores one of the reasons that people are concerned about whether or not lay people are able to have a significant voice in a mixed court, a mixed tribunal, when, as this judge, obviously acknowledges, when the judge has quite a few advantages over the lay judge. And the Conleys, Robin and John Conley, talked about how jurors together, as they discuss and deliberate on a case, each bringing their own kind of individual stories or narratives about the evidence to the case, co-produce or interact together to produce a story about the plaintiff and the plaintiff's approach to the case. So one juror observes that, yeah, his treating doctor's ability to treat patients seems to just prescribe more drugs. And another agrees, yeah, that doctor wasn't very good. I mean, so you see this converging of stories, kind of reinforcing ways in which one of the major actors here, the treating doctor, is judged to be below par. So we've learned a lot from this kind of research. We've learned, especially, I think, informed by some of the qualitative research by anthropologists and social psychologists, political scientists. We've learned that as jurors sit and listen to evidence in a case, they're not simply sitting back as blank slates, but rather actively integrating the evidence as it goes along, developing narrative accounts or stories. And then when they have the story set, after they've heard all the evidence in the case, they try to match it to the available verdict alternatives. But one thing to note is that what jurors bring to this interpretive process is very significant and very important. They bring their pre-existing views about the state of the world, about how stories are constructed, their common sense about justice and what would be justice in particular circumstances. Do biases play a role? Yes, the research has learned, of course, criminal record, some forms of pretrial publicity can also be very negative. Racial and ethnic prejudice, certainly in the United States, has been studied quite a huge amount, and there's some very concerning results about racial prejudice in juries, and alerting us to the need to be vigilant about selecting jurors and controlling the trial to minimize the likelihood of bias. But I would say there's also an optimistic note, is that when people examine what goes into a jury verdict, it appears that how strong the evidence is in a case is the most significant and most important determinant. And also, interestingly, that professional judges are highly likely to agree with the jury's verdict, the ones who have been sitting at trial and listening to very much the same evidence in the case. And I want to tell you about this fascinating line of research called the judge-jury agreement studies. And it's a form of research that was pioneered by these two men in the upper right-hand corner of your screen, Harry Calvin Jr. and Hans Seisel. And they participated way back in the 1950s, before those mock jury studies were even imagined. They participated and developed what is often referred to as the Chicago Jury Project, although they didn't publish their work until the late 1960s. What they did was really quite fascinating. They were deeply concerned about issues of jury competence, and they thought, well, let's see to what extent judges agree with or disagree with the jury verdicts in the cases that they sit on. And that speaks perhaps to jury competence, but it also speaks to the distinctive role of the judge in a case. Because if you see overlap, you are reassured in a way that no matter whether you have legal training or no legal training, you see the evidence in the same way and you would choose the same verdict. But if you see disagreement, you say, this is what a jury would do differently than what a judge would do. And so it really gives you some insight into the distinctive values of the jury system, as opposed to a system that is exclusively run by law-trained judges. So here's this figure that reflects the kind of basic finding of the Chicago Jury Project. And what you see is two bars, the jury convictions and jury acquittals. These are the percentage of trials that in which juries convicted or juries acquitted. And you see that 67% or so, were of the cases over which trial judges presided in this 1950s study were decided in against the defendant in some sort of conviction, and the others, it was an acquittal. All right, so what you see here is this dominance of conviction, which after all makes sense because prosecutors in the United States can decide what cases to bring. So you expect them to bring cases that are basically strong, or where they believe that they have a good, strong case. So you see most of the time here, juries are convicting the defendant. When a jury convicts the defendant, what you see here is that under the blue bar is most of the time a professional judge agrees with that verdict. Judges were asked to say, while the jury's out, give us a kind of judgment that you would have reached had you been trying this case yourself. And when asked about that in terms of jury convictions, the trial judge said, yeah, I would have convicted almost all the time. However, you see it's a different story when it comes to instances when the jury acquits. Here you see at the Chicago Jury Project, actually disagreement with jury acquittals was actually higher than agreement with jury acquittals. So you see right away that at least in these cases where juries select, defendants select a jury to decide their case, they are better off with that jury. They're mostly convicted, but in some instances they're acquitted when if they had gone before a law-trained judge, they would have been convicted. Now you might say, wait, isn't the jury incompetent when it doesn't agree with a law-trained judge? And that's a possibility. One of the things that Calvin and Seisel discovered was that disagreement rates seem to correspond to the extent to which the case evidence was strong or weak. So disagreements were much more likely in cases that were ambiguous, where either verdict could have been reached. And the individual judgments of the judge and the jury really played a bigger role. So incompetence would be one thing, but they mainly occurred in cases with ambiguous evidence, And furthermore, judges usually did not point to jury incompetence as a reason for the difference of opinion. Instead, it seemed that juries brought their norms and values from the community to bear in deciding on the case. So that's a picture of the Chicago Jury Project that gives us some reassurance that most of the time verdicts are going to be similar, and when they're not, the jury appears to have a somewhat more lenient view about criminal defendants. Now, this was the 1950s. A lot has happened since then. So along with colleagues from the National Center for State Courts in the United States, I conducted a project 50 years later. And what we did was use a somewhat different methodology. We gave questionnaires not only to trial judges, but also to the jurors in the cases themselves and to the lawyers. So we got a richer picture of judge-jury agreement. But I point out here the exact same analysis. What was the judge-jury agreement rate in felony trials? And you can see the pattern, although the numbers are a little bit different, the patterns are actually quite similar. Most of the cases result in convictions, but when there are acquittals, you get a greater proportion of judges disagreeing. So kind of an interesting confirmation of that basic pattern, but 50 years later. I thought you might be interested in seeing this project from Korea, South Korea. South Korea has something called an advisory jury. It's an 8-person jury that hears a case, deliberates, and then gives its verdict to a panel of 3 judges who are presiding over the jury trial. And in this case, the judge may, if the jury is not unanimous in its verdict, the judge must come into the deliberation room to share perspectives, to answer any questions, and so on. In addition, the jury can ask for the judge, the presiding judge, to come into the deliberation room to address any issues or questions. So potentially you have much more impact of the judge on the jury, and you would expect somewhat higher agreement rates, and that's exactly what you get. You can see here that disagreement is infrequent, although a similar kind of overall pattern, right? Very, very little disagreement when a jury convicts, somewhat more disagreement for acquittals, again, suggesting that even though more slightly, you've got a defense, a kind of more leniency toward the defendant than even in South Korea, with this interesting combination of judicial participation in the deliberation under these circumstances. And finally, closer to you, you see something kind of similar in Argentina with my collaborators in Neuquén, Argentina. We studied a small number of trials, but again, the overall pattern was very similar. Judges agree with most jury verdicts, and here they agree with the substantial majority of convictions, and disagree more in the acquittals. So no matter the continent, so from Asia, South America, and the United States, you see a kind of similar approach in jury trials. So it's interesting to see, to kind of take a kind of picture or try to draw together these different strands of research. One of the things that I think is somewhat reassuring is that you get a picture of juries basically, going along with the evidence. When evidence is strong, they reach decisions as judges would in line with the evidence. In a way, you might think, well, how can this be? How can a group of lay citizens without any training actually come together and reach a decision that is comparable to law-trained judges? And I think it's that both the judge and the jury do come from similar communities, although judges are much more elite members of that community typically. But lay members do bring strength in their fact-finding. They are familiar with community norms, so are able to enact the community's views and judgments about, what's responsibility for wrongdoing? What do we consider not particularly, even if it's on the books, what do we consider is not really a crime? Some of the characteristics of the jury, I think, also contribute to its strength as a fact finder. There is benefit in numbers. So 12-person juries are stronger and more reliable decision makers than smaller juries. And juries that are required to be unanimous, we now know from research projects, have more robust and vigorous and thorough deliberations than juries that are only required to reach a majority verdict. The best juries appear to be ones where they are quite diverse. And part of the reason might be that people with different perspectives and different views are able to engage with each other in deliberation. It's really fascinated me to learn about Brazil's approach of no deliberation in no deliberation at all, and I'd be fascinated to learn more about how this operates to ensure strong and excellent fact finding in Brazil. So anyway. It's fascinating for me, having studied global juries, to look at the incredible variety of approaches that people take to their institutions, like the advisory jury in South Korea and Brazil's unique approach of no deliberation. One thing I do want to mention, and this, I guess, might help to account for the greater use of juries in criminal cases as opposed to civil cases. And that is the political role that jurors can play. They don't always play it. It's not present in every trial, but they do play a political role. And here in one of the most famous cases in the United States about the right to trial by jury, a case called Duncan versus Louisiana, the Supreme Court of the United States said, providing an accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against the corrupt or overzealous prosecutor and against the compliant, biased, or eccentric judge. So again, we have here this picture of the jury as standing in between government actors who may not be the best and the member of the public who is up against them. The jury is there right in the middle, evaluating the claims of each, and in instances where it concludes there is overreach, being able to make a decision that is beneficial to the defendant. So earlier I talked about the small number of, or small proportion of cases that are decided by jury trial in many countries. So I want to spend a few minutes talking about the broader impact of juries. And what I want to argue to you is that juries are important institutions symbolically and otherwise, and they affect not only what happens in an individual jury trial to the defendant or to the litigants in a civil lawsuit, but also have effects way beyond that. One interesting phenomenon was discovered by the University of Wisconsin legal scholar Michael Lanter, who had the insight that juries have shadows, that he coined this term, jury shadows, to talk about the way in which decisions that are reached by actual juries sitting in court deciding cases affected the outcomes in other cases. In particular, lawyers and litigants might look at those cases to try to get a sense of how, if they went to trial, a jury might decide their particular case. So in some instances, they might decide, okay, there is no way I'm going near a jury with my particular case. They might settle the case. They might abandon the case. Or they might say, it looks like a jury is a great decision maker for me based on this particular case, and I'm going to go forward. So jury shadows suggest that juries affect not only the individuals who are involved in the case, but also other instances in the community. We've also discovered through some fascinating research that having a case decided by a jury and a decision reached by a jury can shore up the legitimacy of the jury system, of the courts, and the decision itself. Here I have a picture of the Chauvin jury trial, which was involved a police officer who killed an individual, and there was incredible public attention in the United States, and the trial was televised. It was during the pandemic, so if you can see here, there's some of the lawyers and other people sitting around the courtroom in masks, and there are various plexiglass things, put with barriers interfering with or setting apart some of the individuals in the courtroom. But what that case, which resulted in a conviction of the police officer, what that case illustrated was the value of a jury trial, especially a public, highly visible jury trial, of a transparent and public resolution of an important dispute. I mentioned, the serious problem that we have with racial bias and police violence against racial minorities in the United States, and this particular case involved just such a interaction. Here, everybody could observe how each side had a chance to present the evidence, to dispute the evidence, to be heard, and to give testimony about, what they observed, what they saw. And then instead of having a government representative make a decision, yes or no, knowing that the prosecution is also from the government, so maybe there's some, potential for government actors to stick together. A jury from the community decides the case and announces it in public. So that transparency and very public nature of the resolution is part of what I think gives jury trials it's a boost. It's why it has a boost for legitimacy. One other thing that we have discovered through research is that juries that are diverse, in particular racially diverse, are especially seen as legitimate. And again, I think it goes back to the insight that most people have, is that if you're represented on a jury, and especially a jury that must reach a unanimous decision, your voice is going to be heard. You're going to have a chance to, in the deliberation room in the United States, give your piece and try to convince other people. So it helps for legitimacy. And what we've also discovered is the incredible impact of it on jurors themselves. The kind of wisdom, received wisdom, is that jury trials are kind of like a public education, and juries in a case receive as they are hearing about the evidence in the case, watching the lawyers and the judge. Judges are ruling on motions, and lawyers are offering different arguments. You really, as a juror, get a practical education in law and legal procedure and the court's efforts to be fair. And most jurors, not 100%, but most jurors do come away from serving on a jury trial with a more positive regard for the jury system and the courts than they had when they started. In addition, it has other effects, participating on a jury. The Jury and Democracy Project, a fascinating project by John Gastel and some of his collaborators, examined jury service and voting records for more than 13,000 American jurors in different cities. In the United States, we have really a dreadful voting rate. We do not have 100% voting. It's way below that. And so I think many people look for ways to enhance and encourage people to participate civically by voting. And in people who were very infrequent voters and served on a jury in a criminal trial were much more likely, significantly more likely to vote in the next election. When I collaborated with John Gastel and one of his students, we also find that civil jurors had similar kinds of effects. People who participated on the traditional type of jury, a 12-person jury that was required to come to a unanimous decision, were also more likely to vote in the next election. So this is so interesting that participating as a juror has these effects: enhanced regard for the courts, enhanced regard for the judiciary and the jury system, plus this bonus of greater civic engagement on the part of people who participate as jurors. Maybe that is one of the reasons why in a new project that Sonia Kutenjak-Ivikovic and I did, we found a very strong relationship between the presence of a criminal jury in a country and measures of that country's democracy. What you see here on this figure are different types of ways of measuring democracy, and we found in every single type that countries that had jury systems were more likely to have stronger measures of democracy in their systems than countries without the jury system. Now, we're not making any causal claims here with this correlational data, but it does suggest that there's a very positive combination of criminal juries and democracy in a country. And the Jury and Democracy Project suggests that jury participation can actually strengthen the democratic institutions of a country. And I'll say, lastly, trial by jury is endlessly fascinating. This is an image from a jury duty, which is streaming on Amazon Freevee. And got an incredible audience response. People around the world seem to love movies and love reading stories about juries, in part because, let's face it, they are fascinating institutions. When we bring people from the community and ask them to resolve some of the disputes that arise in our same communities, sometimes the result is beyond belief. But what we know from research is actually it's often the right result. So I want to close by acknowledging what I think most research shows, that despite problems of bias and problems of some difficulties that juries inevitably encounter, there are some considerable strengths of trial by jury, and social scientists have documented the benefits of having transparent and public proceedings, of having outcomes that reflect the public's view about what's likely to be the best outcome in the case, and what is more likely to be perceived as legitimate. And finally, the democracy-enhancing benefits of jury service give us another reason to favor this institution. So I'll stop right there. Here is some contact information if you'd like to contact me, and I very much enjoyed participating in this presentation with you, and look forward to seeing more about the Brazilian jury in times ahead.
Olá novamente, pessoal. Espero que todos tenham gostado da conferência. Acho que foi bastante instigante ver a forma como a professora articulou as áreas do direito, psicologia e antropologia, né? Acho que essa é uma peculiaridade dessa conferência que foi bastante interessante. Infelizmente, nós não temos a oportunidade de fazer perguntas à professora nesta ocasião, né? Como eu mencionei no início, a conferência foi previamente gravada, assim como as demais conferências também foram, mas nesse caso em particular, a gente teve também a questão de ter tempo hábil para inserir a legendagem, né? Mas acredito que também seja importante a gente mencionar aqui algumas outras questões, né? Que a questão, o tema do júri, ele tem sido bastante estudado no contexto da antropologia do direito, aqui no Brasil também. Né, vou destacar aqui o nome da professora Marisa Correia, da Unicamp, em memória, que já foi mencionada ontem pelo professor Teófilo Riviotes, mas também, é claro, a Ana Lúcia Pastore, né, nossa coordenadora querida, organizadora do ENADIR e coordenadora do NADIR, muitos dos seus orientandos, né, por exemplo, a Bruna Angotti, que fez uma pesquisa super bonita sobre infanticídio, e também, claro, em outros polos do Brasil, né? A gente destaca também o professor Cante de Lima, no Rio, que foi um dos precursores nessa temática, seus muitos orientandos que também continuaram pesquisando o júri no contexto da antropologia do direito, um deles, Luiz Figueira, que também é parceiro aqui do NADIR há bastante tempo, né? Inclusive está coordenando um dos grupos de trabalho aqui no 8º ENADIR e já há várias edições também, né, com a Regina. Outra pessoa que também pesquisa tema do júri e está coordenando o grupo de trabalho aqui no 8º ENADIR é a Rochelle Faquineto, no tema do feminicídio, né? Então, isso só para mencionar aqui alguns exemplos de pessoas que têm conduzido pesquisas nessa grande área da antropologia do direito, né? E correndo o risco de ser injusta com muita gente, porque a gente sabe que sempre tem surgido aí pesquisas novas, e é isso que alimenta e estimula essa área, né? Bem, então eu espero que as reflexões dessa conferência contribuam de alguma forma para o desenvolvimento dessa área de estudos e talvez estimule aí novos pesquisadores a se debruçarem sobre esse tema, né, fascinante. Do mais, gostaria também de convidar todo mundo que nos assiste a participar das mesas redondas que acontecerão essa tarde, né? Hoje a gente tem 2 mesas. A primeira vai acontecer entre as 15 horas e as 16h30, sobre o tema, ela é intitulada Antropologia Jurídica desde as margens, povos indígenas e direitos insurgentes no México e no Brasil. Ontem a gente já teve uma mesa sobre pluralismo jurídico e hoje esse diálogo ele tem um foco um pouco diferente, né, com uma perspectiva comparada também entre Brasil e México. E a segunda e última mesa que acontecerá hoje entre as 17 e 18h30 será exercícios etnográficos em torno do ensino da antropologia do direito em perspectiva comparada, com as muito queridas Bruna Angotti, Bárbara Lupetti e Carmen Fulini. A gente tem aí uma dobradinha de vice-coordenadoras do NADIR, né? A Bruna é a atual e a Carmen Fulini foi a sua antecessora, e vai ser bastante interessante também, né, para refletir sobre esse tema tão caro também, as pessoas que atuam nessa área, né, ensinando a antropologia do direito, e também com essa perspectiva comparada entre o Brasil e o Canadá, né, graças à experiência que a Bruna fez no doutorado sanduíche dela, lá no Canadá, e principalmente também a Carmen, né, que leciona lá atualmente na Universidade de Ottawa. Então é isso, pessoal. Convidamos toda a gente a continuar acompanhando a nossa programação de hoje até sexta. Muito obrigada por prestigiarem essa conferência. Até mais.